All right, ladies and gentlemen, I appreciate your patience. You are here today for cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. Before I introduce the attorneys, I want to introduce my court reporter, Mrs. Stella Grisham, who's sitting before you. She is taking down everything that is spoken in the courtroom today. So if you will help me make her job easier, when you respond loudly, clearly, so she can make out what you're saying. Respond one at a time. Don't talk over one another. Don't talk over the attorneys. Just imagine being in her chair, trying to write down what everyone's saying at the same time. And if everyone starts talking at one time, well, let's just put it this way. You all get to leave. I have to stay here with her, okay? And I want her happy, right? She's happiest when we're talking one at a time and it makes her job easier, okay? So at this time, I also want to introduce to you your attorneys representing the state of Texas and the Van Zandt County Criminal District Attorney's Office. Your elected district attorney, Ms. Tawna Curry. Assisting her today are her assistant criminal district attorneys, Mr. Chris Hartwell, Mr. Alfredo Hernandez. Does anyone on the panel know Ms. Curry, Mr. Hartwell, or Mr. Hernandez? If you can, just raise your paddle, raise your number so I know who you are. Raise them up high. All right. So jurors number 18 and 57. Juror number 18, who do you know? Ms. Curry. And juror number 57, who do you know? All three of them. All right. And juror number 57, how do you know all three of them? Through work? Okay. And juror number 18, juror number 57, your knowledge of these individuals, do you believe it will in any way interfere with your ability to sit as a juror if you were to be selected and render a fair and just verdict based solely on the evidence? Juror number 18? Juror number 57? Thank you, sir. I appreciate it. All right. The attorney representing Mr. Young in this matter is Mr. Bill Stevens. Does anyone know Mr. Stevens? Mr. Stevens maintains a law practice over in Henderson and Kaufman County. Does anyone know Mr. Stevens? Does anyone know Mr. Stevens' son, Mr. Brad Stevens? And for the record, okay, juror number 44, do you know Mr. Bill Stevens or Mr. Brad Stevens? Brad Stevens. Were you aware that Mr. Bill Stevens was Brad Stevens' father? No. Okay. All right. Then I'm not going to ask you any questions about that. Juror number 52. You know his son? All right. So you two individuals, do you believe that your knowledge of Mr. Brad Stevens will in any way prevent you from sitting as a juror should you be selected and rendering a fair and just verdict based solely on the evidence and not based on any knowledge you have about Mr. Stevens or his son, Brad Stevens, who is also an attorney? All right. Thank you very much. Thank you, Mr. Stevens. All right. And the defendant in this case is Reginald Hoyt Young II. Mr. Young, if you wouldn't mind, please standing, sir. Does anyone know Mr. Young? And for the record, the court finds no numbers raised. Thank you, Mr. Young. All right. Mr. Young has been charged with the third-degree felony offense of prohibited weapon. And it is estimated that the trial in this case will take, as I mentioned to you earlier, we're thinking no more than a couple of days. We should hopefully finish on Wednesday by the close of business around 5 p.m. That is contingent upon how long the jury deliberates, something that I have no control over. So we could possibly go into Thursday. So just want to kind of give you that as a time frame. As the jury panel today, you have been seated in the order in which your names were selected using a purely random process. This is done purposely so that no one can manipulate who may sit as a juror on any particular case. During jury selection, it is important that you let us know certain things about yourself because the attorneys will have a very short time during which to get to know you. I'm going to allow each side 45 minutes to conduct their examination of you. During that examination, some of the questions that you are asked may feel to be somewhat personal to you about how you feel about certain things or life experiences or perspectives. I promise you no one is trying to embarrass you in any way or pry unreasonably into your private life. The purpose is to determine if any of you may be influenced by your personal beliefs or knowledge in such a way that you could not serve as fair and impartial jurors in a particular case. You must listen closely to the questions from the court and the attorneys and respond fully and honestly. Your failure to do so could result in a mistrial, and all of our time will have been wasted. When you do respond to a question, please raise your juror number. During jury selection, some of you will be eliminated for legal reasons. After that, each side will have 10 what we call peremptory strikes, which may be exercised for any lawful reason. A peremptory strike removes a name from the list of potential jurors. After the eliminations for legal reasons and peremptory strikes, the first 12 names remaining in the order in which you have been seated will form the jury in this case. The verdict of a jury in a criminal case must be unanimous. That is, all jurors must agree. The trial of a criminal case in Texas proceeds in 2 phases. In the first phase, the jury is called upon to hear the evidence and decide only whether the defendant is guilty or not guilty. This is oftentimes referred to as the guilt phase of trial. Only if the jury finds the defendant guilty does the trial proceed to the second phase, also known as the punishment phase. And in the second phase of trial, the defendant is entitled to choose whether punishment will be assessed by the judge or the jury. In this case, the defendant has elected to have the jury decide punishment should he be found guilty. When we do begin the trial itself, the prosecution will begin by opening statements. The defense will also have an opportunity to give an opening statement. The prosecution will then offer its evidence through witnesses whom the defense may then cross-examine. When the state is finished with their evidence, the defense may or may not present a defense because the defendant is never required to prove his innocence. If the defense does choose to put on witnesses, then of course the prosecution will have a fair opportunity to cross-examine them. At the end of all of the evidence, I will give the jury a written explanation of all of the law that is applicable to the case, along with instructions for the jury on how to reach its verdict through deliberations. If in deliberation the jury reaches a not guilty verdict, then the case is over. If the jury reaches a guilty verdict, then we will proceed to the second phase or the punishment phase of trial. And the procedure for the punishment phase mirrors that of the guilt phase or the first phase. It is the function of the jury in this trial to determine the facts. In doing so, you are the sole and exclusive judge of the credibility of the witnesses and the weight to be given their testimony. Even I, as the judge, am not permitted to influence your evaluation through words or actions during the trial. My job is to decide the law and to be certain that both sides receive a fair trial. Evidence consists of testimony, which is generally direct evidence of what someone saw or heard, and also exhibits. You may draw reasonable inferences from the evidence. What the attorneys say is not evidence, their questions are not evidence, and their arguments are not evidence. All witnesses should be evaluated equally. Just because a witness is a law enforcement officer or a pastor or a teacher or some other occupation, you must evaluate all equally. Evaluate whether they appear to be telling the truth and whether their testimony is consistent with what they have said, or if it's consistent or inconsistent with other evidence in the case. You may also evaluate their appearance, attitude, and behavior using your common sense. A few of the general legal principles that I think it would be helpful for you to know. Oftentimes we will talk about a case having elements. Those are the individual requirements for a crime that the state must prove. For example, an element is that the crime occurred here in Van Zandt County, that it occurred on or about a certain date, that the accused person on trial is the person who has committed the offense, and other particular things to specific offenses. Each of those is termed an element, and the state must prove all elements for a conviction. The burden of proof in this case and in all criminal cases rests solely on the state of Texas throughout the trial. Never at any time does it shift to the defendant. The state must prove every element of the offense beyond a reasonable doubt. The defendant is presumed to be innocent unless guilt is established by legal evidence received before you in the trial of this case beyond a reasonable doubt. If after you retire to deliberate, each of you believes beyond a reasonable doubt that the defendant is guilty of the offense charged, or of a lesser offense permitted under the instructions given to you, it will be your duty to return a verdict of guilty. If you have a reasonable doubt as to the guilt of the defendant, it will be your duty to return a verdict of not guilty. However, the state is not required to prove its case beyond all possible doubt. Any accused person in any criminal case is not required to prove himself or herself innocent. If the defendant chooses not to testify, you may not consider that fact as evidence of guilt, nor may you in your deliberations comment or in any way allude to that fact. The indictment in this case is also not an indication of the guilt of the defendant. It is simply the legal means by which a person in Texas is brought to trial for a felony. The fact that a defendant has been arrested, confined, or indicted for, or otherwise charged with an offense does not infer guilt at trial. The defendant in this case, the prosecution, the public, and our system of justice all require that a fair jury, one without bias or prejudice and free of opinion as to guilt or innocence of the defendant, be chosen here today. A fair jury is one that, not having heard any of the evidence, is not already committed to either side. A fair jury is one that is impartial to both sides and that can and will follow the law as given to it by the court. Put another way, an impartial jury is defined as one which does not favor a party or an individual because of the emotions of the human mind, heart, or affections. It means that the defendant, the case, and the issues involved in the case must not be prejudiced. Everyone has biases. Please be honest with yourself and the attorneys about any bias you might have one way or the other that may affect your ability to be fair and impartial in this case. Just because you have a bias in one direction or another does not necessarily disqualify you from serving as a juror. You may have a bias that you can set aside in order to follow the law as instructed. However, if you have a bias that you cannot overcome, then you will not be qualified to serve on this jury. Just because the defendant has elected to have the jury assess punishment in the event a guilty verdict is returned does not mean that that election can be used as any indication during the guilt phase of trial. The law requires a defendant to make this election regarding punishment at this time of the trial. The parties will need to know if you can fairly consider the full range of punishment in this case. In this case, the possible punishment range is from a minimum 2 years in prison up to a maximum 20 years in prison and a $10,000 fine, a possible $10,000 fine. All right, who will be doing the jury selection for the state? Ms. Curry? All right, you may proceed.
Good morning. Yeah, that's about a C plus. All right, I'll let it slide. I'll let it slide. I'm going to start off by apologizing to y'all for my voice and for the fact that I have a cough drop in my mouth. I'm not eating candy, I promise. But last week at this time, I couldn't talk at all. So we're doing better, okay? Just one of those fall colds that a lot of us get. Who wants to be on a jury today? Nobody? I usually get one or two. All right, who's been on a jury before? It was that bad? So since I didn't get 12 volunteers, I guess we're going to have to go through this process. Somebody who's been on a jury before, tell me what a jury does. If you were paying attention, the judge just told you, but he kind of told you in some legal terms that he's required to use. What does a jury do? Oh boy. Judge, we're not going to get done in 45 minutes if it's like this. What does a jury do? Listen. Very good. That's the first thing a jury does. Listen to the evidence, right? What else does a jury do? What if the evidence doesn't agree? What if some says it's blue and some say it's red? What does the jury do? They decide who's telling the truth, right? Judge told you the jury is the judge of the credibility of the witnesses. That's fancy words for the jury decides who's telling the truth, right? Okay, what else does a jury do? They return a verdict. What's that verdict based on? Evidence. Very good. And only the evidence, right? And what the judge told you just a few minutes ago was what the lawyers say is not evidence. The evidence will come to you from the witness stand, sworn testimony, from exhibits that are admitted into court. They might be videos, pictures, recordings, physical items, anything. That is the evidence. What else does a jury rely on? The law. The law, right? Now, any lawyers out there? I didn't think so because I didn't recognize any of you as being lawyers. So what are you going to do for the law? At the end of the trial, if you're selected on this jury, the judge will give you the law in writing. That is the law that governs this case. And that is the only law that you need for this case. Okay? It'll be everything you need. So those jurors who are selected on this case are supposed to make their decision. They'll take an oath to make their decision only on the evidence they hear and only on the law that the judge gives them. Not what they might think the law is, not what some other law might possibly be, not what the law of somewhere else is. That law and that evidence. Okay? So now, what's this process about? This process is to find people who can do that. Or basically, as the judge told you, to eliminate or deselect people who can't do that for some reason. What's one of the great things about America? There's no thought police. We are free to think whatever we want, right? We can think a law is stupid if we want to. But in here, if you're selected to sit on a jury, whether you agree with that law or don't agree with that law, you'll take an oath to uphold it, right? Personally, I do not like the seatbelt law. When you're as short as I am, that seatbelt comes about right across here, and it makes your neck itch, and it just is a pain. I don't like it, and I'll be honest with you. Maybe if it's a short trip, I might not use it because I don't like it. Okay? But if I were on a jury and the allegation was that a person violated that seatbelt law, as much as I didn't like that law, I would have to take an oath to enforce it, and I could do that. I don't have a fundamental disagreement with it. I just don't like it. So I could take an oath to enforce that law. One of the things we're going to do this morning while I'm visiting with you is see if any of you have such a fundamental opinion about certain laws that you couldn't enforce it, right? And if you don't, that's fine. Or if you do have that type of opinion about the law that you can't enforce it, that's fine. Having an opinion, not being able to enforce the law yourself, that's not a crime. We'll say thank you for coming and responding to your service, but you won't be selected for this jury. All right? Now, let's get down to fairness. The judge said we're looking for fair jurors. So my question to you is, who is unfair? I got one. Very good. Very good. Actually, in reality, most of us are unfair about some things, right? We have been inundated for the last, I don't know how many weeks by political advertisements. I am so sick of hearing them. Some of them I can recite from memory. I've heard so many times. Who has an opinion as to whether all political advertisements are true? Who thinks all political advertisements are absolutely true? Who thinks all political advertisements are not absolutely true? Some are untrue. Yeah, if you've seen the same ones I have, some of them are untrue, right? So if this were a trial about political advertisements and truthfulness, those of you who just raised your card, could you be fair? No, you already have an opinion, right? I bet a lot of you have already voted for president. You've already made up your mind. If this trial were about who should be president, you already have an opinion, right? So you would not be a fair juror. That's all we're looking for, is people who can make the decision as the law requires only on the evidence and the law that the judge gives. People who do not already have their minds made up. Okay? So that's what my questions are going to be about today. Do you already have your mind made up about something that's relevant to this trial? And if you do, hey, that's not a problem. You'll get to go home. Okay? So let's get started then. I'm going to follow up a little bit on what the judge said about the burden of proof. What's the burden of proof in a criminal trial in our country? Come on, I know you've heard it on TV. What is it? Beyond a reasonable doubt. I'm going to go back to something that I usually say and I didn't have written down this time. The judge told you, I told you that jury selection is really deselection. If you have one of those opinions, then you're probably going to be eliminated as one of the 12 people who serves on this jury, right? How are we going to know if you have one of those opinions? What'd you say, man? Asking questions, and you have to answer the question. That's right. You know who winds up on a jury? The 12 people that wind up on a jury are usually the 12 people that were the quietest out here. Because we have to presume that you don't have an answer to our questions, and therefore you don't have one of those preconceived opinions that would make you unfair for this trial. So everybody's been pretty quiet so far, and everybody told me they don't want to be on a jury. Not even one of y'all wants to be on a jury. So I would suggest we start talking. All right? What's the burden of proof in a criminal trial? Beyond a reasonable doubt. How many Law and Order, FBI, all those kind of shows fans do I have? Yeah, y'all should have known that. Beyond a reasonable doubt. Now, it's very irritating to me when I watch those shows that sometimes they get it wrong. A lot of times they get it wrong. Beyond all doubt, beyond the shadows of a doubt, beyond any doubt, beyond this, beyond that. Our Constitution says beyond a reasonable doubt. Why? The judge already told you the state does not have to prove it beyond all doubt. Can I ever prove to you something beyond all doubt? Only if you saw it yourself, right? Guess what? If you saw it yourself, are you going to be in the jury box? You're going to be on the witness stand, right? Okay, that's why it's not beyond all doubt. Now, criminal trials, that's a high burden of proof, and it should be. It should be, because what's at stake in a criminal trial? Sorry? Someone's freedom, right? Beyond a reasonable doubt is actually the highest burden that we have in our justice system, whether it's civil or criminal. But it's not a burden that we're afraid of. It's a burden that we welcome, that we think is just and fair. And it's a burden that we're going to ask that you tell us that you can hold us to, but also that you not hold us to beyond all doubt. Why is that? It's not possible. That's right. It's not possible for us to prove to you something beyond all doubt unless you saw it yourself. Right? So who says, you know, Tanda, I understand that criminal trials are serious. The judge has told us that this is, if this man is found guilty, it's a 2-year to 20-year in prison case. I just can't work with beyond a reasonable doubt. you would have to prove it to me beyond all doubt before I could convict a person and consider sending them to prison. Anybody? So the reverse must be true. You can work with beyond a reasonable doubt. Right? Now, the weird thing, the weird isn't a good legal word, but the odd thing is that our legislature does not give us a definition of a reasonable doubt. Each juror gets to decide that individually for themselves. Okay? Everybody okay with that? Anybody have any questions about it? By the way, jury selection is the only time you get to ask us anything. So if you have a question, raise your card. But everybody here is telling me that they can work with the burden of proof beyond a reasonable doubt. And that if in fact the judge tells them that's the law, as he already has this morning, and I expect he will several more times, that that's the burden and only that burden that you will hold the state to. Everybody? Now, what do we have to prove beyond a reasonable doubt? We have to prove those elements that the judge talked about. Again, this part, jury selection, is not evidence, right? Because I'm talking, and that's not evidence. So I am not allowed to tell you the facts of this case because I don't get to testify. And I am not allowed to ask you, then, what are you going to do in this case? Because you haven't heard any evidence, right? If the judge passed out verdict forms right now and said, guilty or not guilty, you'd have to check not guilty, right? You haven't heard any evidence. So I'm not allowed to go into that with you, but I can talk about what the elements of the offense are. And as Judge told you, the first element is that it was this specific defendant, Reginald Young II, on or about November 25th of 2020. Now, 2020, that's been a while back, right? A lot of things have happened since 2020 and now, right? One thing that you'll learn if you're selected on this jury is that we don't get to talk about why the offense was in 2020 and the trial is in 2024, but I can tell you it's not the fault of anyone in this court, okay? Anybody who says, I would have to know, I can't do it without, I can't sit on a jury without knowing why the offense is so long ago and we're just now having a trial. So everybody's telling me that's something you can absolutely put out of your mind if you're selected on this jury. My voice is not going to last very long, y'all. In Van Zandt County, Texas, the defendant intentionally or knowingly, what's that mean? I'm sorry? It's a culpable mistake. Basically, it means on purpose. And the judge at the end will give you written definitions when he gives those jury instructions of intentionally and knowingly. But basically, to sum it up, just means on purpose. Remember when you were a kid, got in trouble? You said, but I didn't do it on purpose. Right? Right? That's a phrase we all can work with. Intentionally or knowingly possess a short-barreled shotgun. And we're going to spend a lot of the rest of my time here talking about that particular element and the law that applies to that element. Okay? Second Amendment of the United States Constitution, what's it say? Right, the people to keep and bear arms shall not be infringed, right? That amendment is very near and dear to me, as I'm sure it is to many, many of you. I spent 4 years on the women's U.S. pistol shooting team. I'm a hunter. I like firearms. They are fun. I believe that that is a right I was born with. Anybody agree? Absolutely. It's not a right that a government, federal government, state government gives to us. It's a right we were born with. It's one of the big things I like about living in the great state of Texas. Not all states, not all cities agree with that. The question we have to address in this mordial, and this is where we're getting down to those feelings and opinions about law and whether or not you agree or disagree with the law, and whether or not, even if you disagree with it, could you still enforce it? The question we have to deal with is, does the government have the right to limit that? Second Amendment. Who thinks yes? Everyone in the back? Who thinks no? So our law in the state of Texas and federal law says that a convicted felon surrenders their right to possess a firearm. In the state of Texas, 5 years after they finish their sentence, they can have one at home. Federal law does not have any exception. Federal law says you're a convicted felon, you can never possess a firearm again. Is there anyone who believes that the federal government or the state government, because of the Second Amendment, do not have the right to impose that restriction? If you hold your card up till I call your number, then you can put it down. Number 4, number 6, number 15, number 23. Next row. All right, number 44. Anyone else?
State what you said,
I'm sorry, sir.
state what you said about federal government, state government, right?
To impose a law that says a convicted felon cannot possess a firearm. Everybody hear me? Both our federal government and our state government have laws that say convicted felons cannot possess firearms. That right. There's anyone other than the numbers I've called who don't believe that our governments have the right to impose that law. All right. Now, those whose numbers I called, if you were selected to sit on a jury where that law was being litigated, could you enforce it? 4, 6.
And Ms. Curry, did she say, I don't think so? Can you develop that, Ms. Curry, please?
Okay. I'm gonna have to ask him to give a definite answer. I don't think so. Doesn't make any sense. You would not be able to. Okay. Number 15, would you be able to? Oh, I'm sorry. No, okay. 23. 44. Thank you very much. Look at that. Nothing bad happened. Right? Sure. All right. Now, so we see that our governments have determined that they have the right to limit the Second Amendment in some instances with regard to a certain class of people, right? Now, our governments have also determined that they have the right to limit the Second Amendment based on certain classes of guns, right? Machine guns. Illegal to possess a machine gun. Short-barreled shotgun, short-barreled rifle. Illegal to possess. Zip gun, some other things. Illegal to possess. Even by a law-abiding citizen. Okay. Now, got the Second Amendment that says the right of the people to keep their arms shall not be infringed, right? But yet, the state of Texas and the federal government both say It's unlawful to possess a machine gun. It's unlawful to possess a short barrel shotgun. It's unlawful to possess a short barrel rifle. Who here thinks that the government does not have the right to impose that law? All right, again, if you'll leave your cards up until I call, that'd be great. 4, 6, 7, 8, 9, 15, 17, 23. Next row, anyone? Oh, I missed 19, sorry. 36. Over here again, 39, 44, 50, 51. 35, did I miss you? Is your card up or down? Okay. 50, 51, 61, 64, and 65. Now, of those people, this trial is about that law. The allegation here is that the defendant violated Texas law by possessing a short-barreled shotgun. In other words, a shotgun with a length of barrel that was less than 18 inches. Those of you who just raised your card, or anyone else who didn't raise their card, who says, because of my beliefs in the Second Amendment, I cannot enforce that law. And again, please keep your cards up until I call your number. And ladies and gentlemen, let me remind you one more time. If you're selected to sit on this jury, you're going to take an oath to enforce that law. So if you can't take that oath and you can't follow that oath, now is the time to let us know. All right. So 4, 6, 8, 15, 17, 23, 39, 44, 50, 51, 61, and 64. So that's not quite everybody who raised their card about disagreeing with it. The rest of you who disagree with it, it's kind of like the seatbelt law. You don't like it, but you can still enforce it. Correct? Yes, sir.
We deal strictly with a felony, a person that is a felon, and owning and being able to possess those things.
No, sir.
Okay.
This is an ordinary, my question goes to,
Because I was under the impression that you could have an automatic weapon if you had a stand. You have a permit.
federal law, yes.
And the length of the shotgun, I was under the impression was 16 inches, not 8.
Rifle is 16, shotgun is 8. Okay.
That's my issue with the question is clarification, making sure that everybody is fully aware of what the law says.
And for my question, an ordinary citizen, not a convicted felon, ordinary citizen. All right, is there anyone who would change your answer based on those clarifications? All right, wait, so 7, you could not enforce that law? 8, I already have you. 47 and 35, you could not enforce that law? Anybody else? Anybody here who's ever had any experience working on or repairing firearms? 7, 8, 34? Only with your husband? Quite a few. Only 3 I'm gonna pick on you a minute. If I took the barrel out of your handgun, how quickly could you put it back in? Minutes.
Seconds.
I'm sorry,
Seconds.
seconds. What about a firing pin? If I took a firing pin out of a weapon, very quickly. Again, seconds. Did everybody hear what he said? The rest of you who've worked on firearms, you, sir, I think you said you had. Do you disagree? If I took the barrel out of your pistol, how quickly could you put it back in? All right. What about a firing pin? How quickly could you put it back in? Couple minutes? the law that prohibits possession of certain classes of guns, the law that prohibits felons from possessing any gun, does not require that the gun have all the parts. It can be missing a barrel, it can be missing a slide, it can be missing a fire pin, it can be missing an ejector, an extractor. Doesn't even have to work. Why? Because you can make it work real quick. Real quick. Some of those parts you can pop back in, as juror number 3 said, in a matter of seconds, in a couple minutes. Doesn't make it any less dangerous if you can pop a part in a matter of seconds or minutes, right? Same goes for the law about short-barreled shotguns, short-barreled rifles, machine guns. It doesn't have to have all the parts. Doesn't have to operate. Is there anybody who says, well, Ms. Curry, now that you've told me that, if I were on the jury, the gun would have to operate before I could convict someone. The gun would have to have all the parts before I could convict someone of possessing an illegal weapon like a machine gun or a short barrel gun. Anybody at all? All right, so I'm going to make you commit to this one, folks. If you're selected to sit on this jury and you take that oath to follow the law, and the law is that the firearm does not have to have all the parts, does not have to operate, and you believe everything has been proved beyond a reasonable doubt, raise your card if you can return a verdict of guilty. Well, that's not very many. I must have asked a bad question. If you're selected to sit on this jury, or any jury, where the offense alleged is possession of a prohibited weapon, that's what the law calls a machine gun, short-barreled rifle, a short-barreled shotgun, and you hear all the evidence, and you believe that the state has proved the defendant possessed that weapon on there about that date in that county, but the evidence showed that the firearm did not work, was missing a part, and you still return a verdict of guilty if the judge tells you that's what the law is. Yes, I can do it. It might be missing a part.
It's just in his possession.
It's in his possession. It might be missing a part that it would need in order to shoot a bullet. But you believe beyond a reasonable doubt he had it. Can you return a verdict of guilty? All right. Anybody who can't? Anybody who cannot?
Yeah,
I can't make your questions too late.
Okay. All right. Okay. Raise your card again if you need to know more or you have a question about that. All right. 4, 6, 15. I'm okay with y'all. 7, 8. I'm okay with you. 17. I'm okay with you. All right. Anybody else want to talk about that? Have any questions about that? All right. Texas defines a short-barreled shotgun as a shotgun with a barrel length of less than 18 inches. No reference to single shot, over and under, side by side, semi-auto, no reference to that. Everybody okay with that? Sure.
Is there any type of other places along the street? Because they do make it.
Oscar shot.
If you check it, it'll have a barrel length of right at 18 inches. There's a lot of snake charmers you can buy that have a barrel length right at 18 or 18 and a quarter.
Oh, shit.
I bet you it has a rifle bore. There's a shotgun that's fine as a sweet rifle bore would make it exception. Okay?
Does that make it a rifle or a shot?
Depends on what he's shooting though. Depending on what caliber he can shoot. Designed for shotgun slugs, but with a rifle bore. Okay. Okay. All right, we're gonna turn the page and get off of that. Is there any more questions about it? Yes, ma'am, number 52. My question here was about an ordinary person. Right? All right, so let's talk briefly. Yes, ma'am. You're freezing to death, you too.
I know. This lake is freezing.
Who's not freezing to death? Who's not freezing to death? Sorry, ma'am. Sorry, ma'am. If I turn it off, everyone's gonna get hot.
Yeah.
Keep your lane. I'm not in trouble. All right. Let's talk for just a minute about some of the witnesses we may call in this case. Obviously, judge has already told you we represent the state of Texas. We're the ones bringing the charge. We bring a charge when law enforcement makes an arrest. So some of our witnesses in this case are going to be law enforcement officers. Is there anyone here who, and this goes back kind of to the fairness aspect of what Judge was saying, and if you paid attention, he said preachers, law enforcement, all kinds of people, classifications, they should start out the same as any other witness. Now, in today's society, a lot of law enforcement are, let me back up. One bad apple tend to give the whole basket. And, right? I think we would all agree that we've all heard news stories about some bad law enforcement officers who have done some things they shouldn't have done in the past few years, right? Does that mean all law enforcement officers are bad? Flip side, a lot of y'all probably have law enforcement in your family, maybe even yourself. You probably have a lot of respect for those people. Does that mean all law enforcement officers are good? So is there anybody who says, because of my personal relationship with a law enforcement officer, or because of a personal experience I've had with a law enforcement officer, they're going to start out, when they take that witness stand, I already know their credibility is above or behind another witness? Anybody like that? All right, number 3, thank you, sir. Number 17. Number 15, all right. Anyone else? All right, thank you very much. Now I'm gonna make it, oh, yes, sir, number 38. Okay. I'm gonna make it a little tougher. And I will tell you that one of the witnesses we expect to call is an ATF agent, Bureau of Alcohol, Tobacco, and Firearms. How long has it been? 20 years? More than 20. They got a really bad rap. They made some mistakes, a few of them, but the whole agency got a really bad rap on some things that transpired. Is there anyone who says, because of that, or for any other reason, maybe you've had a personal dealing with ATF, I just can't judge them the same, judge an ATF agent the same as I would another person who was called to testify? Anyone at all? Number 30? Number 52? Yes, sir. Now, I'll change my question. I'll change my question. Above or below? Would you judge them above or below an ordinary lay witness who was non-law enforcement? All right, 3, 15, 17, 6, 30, 56, and 38. All right, anyone else? Anybody in here have an FFL, federal firearms license? Used to? Anybody who used to have one? All right. Anyone else? All right, so let's go to my last area of questions here. Judge told you that when a criminal defendant is found guilty in the first part of the trial, the second part of the trial proceeds to punishment. And we have to talk about it now because it's the same jury that will do both. So we can't come back and do a different jury selection if there is a verdict of guilty. So I want to talk about the punishment range here. We've told you what the punishment, what the offense is, the elements of the offense. Now, our law says that that crime is ordinarily punished by between 2 years in prison and 10 years in prison. Okay. Again, I'm a lawyer. I'm not giving you evidence. So I cannot, it would be totally unfair of me to ask you, if this guy's found guilty, what punishment are you going to get? You don't know. That 2 years to 10 years is a big range. Why do we have big ranges? Some ranges in Texas are 5 years to 99 years. I'm sorry? Correct. We have ranges for 2 reasons. Not all criminal defendants are the same. Some of it might be the first time they did something. Some of it might be the 15th. Who knows? Not all offenses are the same, right? You could have somebody, the example I usually use is murder. Couple has been married for 50 years. The wife has terminal cancer. She's suffering and suffering and suffering. And the husband can't take it back. So what's he do? He goes over and he pulls the plug on the machine that's keeping him alive. Intentionally or knowingly caused the death of another. He did. You might have a 10-time convicted felon walking down the street, escaped from prison, took a guard's gun, shot the first people he saw and took their car. Murder, right? Intentionally, knowingly took the life of another. Those 2 offenses deserve the same. Not at all. Not at all. That's why we have punishment ranges. And sitting here right now, you don't know anything about this case. You don't know if it's an egregious case. You don't know if it's an escapee who shot somebody in a car to steal their car. You don't know if it's a man who pulled the plug. You don't know if it's a person who's been convicted no times in the past, 10 times in the past, right? So I'm not asking you what you would do. I'm asking you if you can consider the whole range, right? Can you consider giving 2 for someone you found guilty of possessing a short-barreled shotgun? Yes. Anyone who cannot? Number 30 and number 6. All right. And a lot of you who've already raised your cards on can't enforce that law, I understand. Okay, you couldn't enforce the law at all. Anyone else besides those who say they can't enforce the law at all, who could not consider, just consider that there might be a circumstance where they would give 2 years for the crime of possessing a short-barreled shotgun? How about 10 years? Anyone who says there are no circumstances that I could even consider 10 years? Yes, ma'am, number 4.
Saying consider the 2 to 10 or we not?
Could you consider giving 10 years, not knowing anything about the crime? It may be a really bad one. Not knowing anything about the person. He could have a long history.
Yeah.
Could you consider giving 10? All right, now, yes, sir? No? Okay. Now, let's throw in this fact. Our law says if the person convicted of this crime, possession of a short-barreled shotgun, has been convicted of a felony in the past and has gone to prison for that felony. In other words, it was serious enough that they didn't get probation. They actually went to prison. Then the punishment range becomes 2 years to 20 years. Okay? So under those circumstances, if that were proved to you beyond a reasonable doubt that the person had previously been to prison for a felony conviction, could you consider 20 years? Not knowing anything about how bad the offense is, not knowing right now whether that was the only conviction or whether they had more, would you consider 20 years? Anyone who says, I couldn't consider 20 years. All right, 4-6, I've got you. 52, I've got you. 47. Anyone else? 44. All right. I don't know how long I've been up here, but my voice isn't gonna take much more, and I am out of cough drops. Y'all don't want to see me have one of the coughing fits I've been having lately. So I'm gonna wrap it up, but before I do, I want to ask one more thing. If you've been sitting out there thinking, oh, I bet one of those lawyers would want to know this, because it's really something that happened in my life that I can't put out of my mind. It would affect me if I were sitting on a jury where the offense charged was possession of a short-barreled shotgun. Well, now's your chance. Or even if it's just anything not that specific, anything at all that you think we would want to know about you and your ability to be fair and impartial, your ability to decide this case only on the evidence and the law that comes from the judge. Anything at all, now's your chance. Great. And let me say this, ladies and gentlemen, if it's something really private, we can approach later and you can talk about it just in front of the lawyers and the judge. Okay? All right, so who has a response to that, what I call the catch-all question? Anyone? Number 30, I got you. Number 52. Number 31. Anyone else? Number 31, is it something you'd rather approach the bench about, or is it something you don't mind talking about here? Okay, go ahead, sir.
We should know that was a former detective violent crimes
Okay, for what agency?
in South Carolina.
In South Carolina. Thank you, sir. Anyone else? Number 30. Yes, sir. I think we've got you covered, sir. You're all right. I've got you covered. Anyone else? All right, ladies and gentlemen, thank you very much for your attention, and we look forward to working with the 12 of you who are selected.
And you use exactly 45 minutes.
Oh, what do you know?
All right, ladies and gentlemen, it is approximately 11:30. I'm going to give you an option. And because this is America and this is the great state of Texas, we're going to vote on it. All right. Option number 1, we recess for about an hour 15. We take a lunch break. You leave, you come back, and then we continue with Mr. Stevens and the defense jury selection. Or we take a 15-minute break. Everyone stretches their legs, uses the bathroom. We come back and we do another 45 minutes. And then it'll take the court about 30 minutes to pick the jury. And then you go home. Option 1 is lunch. Option 2 is go home earlier. Option 1. Oh, for those of you who didn't see her, she wanted to vote for option one. And then when she didn't see you all vote for option one, she pulled it back down quickly. Maybe someone, option two? Yeah, there we go. I just want to make sure that they were going to vote. We're going to make sure they're going to vote. Maybe one of these other ones will take you down to the vending machine and buy you something. All right, so with that, we'll take a 15-minute break. I'm going to ask everyone to be back in your seat no later than 11:45. Ladies, if there's still a line for the bathroom, there's restrooms downstairs also in the basement. All right, there's a men's up here, women's right here. There's also men's and women's in the basement. Ladies, if there's still a line, then don't worry about it. We won't start without you. Okay. All right, when you exit the side and the back and re-enter, leave your numbers right there. All right, Mr. Stevens. It's your crowd.
All right, ladies and gentlemen, I'm not going to take as much time as the prosecutor did because there's no point in me going over everything she did just to beat a dead horse, so to speak. But first of all, I want to tell you about myself, okay? I'm a former Dallas police officer. I formerly served in the United States Army back during the Vietnam era war. I have 2 kids. One of them works with me. He's an attorney. My older son's in Dallas. He's a banker. I have 2 beautiful grandkids. So that's a little bit about me. And by the way, I live at Cedar Creek Lake. So originally from Dallas. But anyway, that's me. Just in case y'all want to know a little bit who I am and where I'm coming from. First of all, as the judge says, I want to thank each and every one of y'all also for being here. It's about the best thing you can do to serve your country other than the military, police officer, school teacher, things like that, that's serving our country. But I do appreciate each and every one of you being here because, you know, they don't do this in Russia. They don't do this in Afghanistan. They don't do trials like they do in the United States. And so I sincerely say that I appreciate each and every one of y'all taking time out of your schedules to be here because I know you've all got places and things you'd rather be doing than be here. But again, I do appreciate it. Ladies and gentlemen, I just want to kind of stress the point that during a criminal trial, what's called the burden of proof is on the state. It never shifts to the defense. All we have to do, ladies and gentlemen, is just show up. We don't have to put on any testimony. I don't have to call any witnesses. I don't even have to cross-examine the state witnesses if I choose not to. Now, it's not going to be that way, but I'm just trying to get the point over that all the defense has to do is just show up. It's completely up to the state to prove their case beyond all reasonable doubt. And that's what we're talking about in this case, ladies and gentlemen. It's going to be reasonable doubt in this case. You know, y'all are going to be the judge of the credibility of the witnesses. Y'all are going to be judging the evidence. The judge will give us the law. However, y'all will be the judge of the credibility of each and every witness. You know, y'all might believe something they say, you might believe everything they say, or you might believe nothing they say. It's completely up to you folks as to judge the credibility of the witnesses. Now, I know Ms. Curry asked y'all this a while ago. I'm going to ask it one more time, though. Is there anybody here that would put a police officer's testimony on a higher level to begin with than any civilian witness that may testify? Yes, sir. Do you feel that way? In other words, anytime a police officer gets up, you're going to feel like that his testimony is going to be credible and more important than anybody else's? Okay. Okay. Yes, ma'am. Number 7. Tell me. Do you think, would you put a police officer's testimony up higher than anybody else's? Okay. Do you have a law enforcement in your family or? Okay. Where did he work? Oh, Dallas. Okay. Yes, sir. Number 8. Okay. would you put their testimony ahead of somebody else as far as credibility goes? Okay. And I saw some other paddles go up. Yes, number 32, please. You would put a police officer's testimony up higher than anyone else's? Okay. Is there, do you have law enforcement in your family, or you do? Okay. You said your husband? Okay. Is he a police officer? Okay. And 57, yes, sir. Okay. Do you have officers in your family or law enforcement? You are? Okay, sir. Where do you work? In Van Zandt? Okay. Well, I noticed a while ago you knew everybody, so I figured. Anybody else on this side of the room? How about this side of the room? Anybody feel like that they would start a police officer's testimony on a higher level than any civilian police officer? All right. Yes, sir. You'd start the police officer on a higher level of credibility than, okay. Do you have, may I ask, do you have law enforcement in your family or no? I'm sorry? Does it? What the state and I are both looking for, we're looking for 12 fair and impartial jurors. 12 people that will listen to the evidence, that will render a judgment based upon what the evidence shows. We don't want people that's going to get back there and not really pay any attention and just vote with the masses. We want people that are be hard-minded people. Look at the evidence, vote guilty or not guilty on your conscience. Just, we don't want people back there pulling a straw or just voting with the masses. I've noticed on the jury cards that some of the folks have been on civil juries before. Some have been on, has anybody been on a criminal jury? Yes, ma'am. Did y'all, not to know what kind of case it is, did y'all reach a conclusion? You did? Okay. And yes, number 50.
Say,
Did y'all reach a conclusion on it? Okay. And 51?
play out.
Okay. Okay. And I saw another, yes, sir, 37? Did y'all finish the case or okay, went to jury? Okay. And 29? Did y'all finish the case? Did he go to the jury? Okay. Anybody on this side? Yes, sir. Number 11. Yes, sir. Did not. Okay. Number 34. Okay. 36. Went all the way through. Okay. And 46. All the way to conclusion. Okay. And 59. Okay, sir. All right. Thank y'all very much for that. Ladies and gentlemen, I'm going to leave y'all with that. I'm not going to sit here and keep talking. Again, I want to thank y'all for each and every one of you for being here. It's really important that y'all are here. And we hope to pick 12 people that will pay close attention and render a verdict according to the testimony and the evidence. Thank y'all very much.
Thank you. Please be seated.
All right, again, ladies and gentlemen, thank you for your patience. This time, Ms. Wilson is back, and we do have the jury that have been picked in this case. When you hear your names, please bring your personal belongings and come have a seat in the jury box. Ms. Wilson.
Elizabeth Dennis. Juanita Pennington. Eric Warhol. Sherry Huddle. William Hilliard. Jason Sanderson. Stephen Brown. Robert Baldwin. Bradley Burleson. Pamela Josie. Courtney Pennant. And the alternate is Cindy Wines.
Please turn off your phones. All right, ladies and gentlemen, I'm gonna have you all rise so I can administer the oath of the jury. You'll all raise your right hands. You and each of you do solemnly swear or affirm that in the case of the state of Texas versus Reginald Hoyt Young II, you will a true verdict render according to the law and the evidence, so help you God. All right, thank you. You may be seated. All right, to the remainder of the panel, I want to again express my gratitude for your patriotism and being here today. I hope that you found the jury selection to be not so much entertaining, but informational and educational part. I learned some things about firearms today that I didn't know. So I hope that you can appreciate the purpose of what we're doing here today, and that when you go out and you tell other people that you were on jury duty, it wasn't about, oh, I got a summons for jury duty and it was so boring and I hated being there. But you can go back and tell them that this is a fundamental part of our criminal justice system and encourage them to answer their summons. Okay. For your appearance here today, you are entitled to $20. If you would like to donate any of that, all of it or any portion of that to one of the nonprofits that have been approved by the Van Zandt County Commissioners Court, you can see Miss Wilson here as you leave. She can give you a form. You can redirect that. Otherwise, you're welcome just to go on home and we'll send a check to your address. Okay. So many people always ask me, Judge, why do you bring in 60 people or 100 people when you're only picking 12 or 13? And I tell them, obviously, we don't know who is going to be summoned at that time. And when they come, we don't know what their life experiences are going to be. We don't know what philosophies they have, perspectives they have. We don't know what law is perhaps going to be used in that case where someone might have an opinion on it. So it takes more of us to get down to the group that we need. And so I don't want you to think that because you weren't picked that your time wasn't wasted. And those of you that didn't get picked, you can quit smiling now. All right. They've already been picked. They've already been picked. Okay. So again, thank you for your time. Thank you for your attention. You are excused at this time. Mr. Stevens, Ms. Curry. All right, ladies and gentlemen of the jury, I want to give you just a few more instructions and then I'm going to send you home. Okay. We're not going to start the evidence today. This is what you can expect during the trial tomorrow. And there's a scheduling conflicts that we need to work around. So tomorrow we're not going to begin until 1 p.m. Okay. 1 p.m. So what you'll do is when you arrive to the courthouse, you'll come and in just a few moments when I'm through giving you these instructions, you'll go into the jury room with Deputy Martinez. He's going to get your contact information. We ask that you give us the 2 best contact numbers so that we can reach you in case there's inclement weather, water main break, something that could cause us to delay. We'd want to call you at home and keep you at home rather than bringing you up here. When you do report tomorrow, you're going to report to the jury room. You will not re-enter through the courtroom. Today, when you go in there, you'll exit out a back way. So you'll go in that same way because we may be doing things in here that you do not need to be privy to at the time. Okay. So We'll begin tomorrow at 1 p.m. and when we do, then we'll have the state present the indictment to the defendant. He'll enter his plea before you, after which then the state will have the opportunity to give their opening statement. Defense can then give their opening statement immediately thereafter, or the defense can wait until the close of all of the state's evidence and then they can present their opening statement. It's an election that they get to make tomorrow. After which the state will have the opportunity to present its evidence first, state bearing the burden of proof in this case and not shifting to the defendant. They will call their witnesses first, they'll put on their evidence first, they will argue first, at the very end, they will argue last. Okay, they'll call their witnesses, I'll swear in each witness before you. The witness will then take the stand. We'll have direct examination by the state through questions. There may be objections by either the defense or the state. And if the court has to entertain an objection, you're not to speculate or worry about what the objection is for. I will deal with that and then we'll move forward. After the state has called all of their witnesses and marshaled all of their evidence, then the state will say in front of you that they rest their case. They admitted all of the evidence that they seek to in the case. After which then the defense will be given the opportunity to present a case if they so choose, remembering that there's a presumption of innocence. And that alone is enough to acquit the defendant. So the defense doesn't have to call any witnesses. They don't have to put on any evidence. But if they do, as I've already told you, then the state will have a chance to cross-examine their witnesses and their evidence. Okay. And that process will continue until we've heard all of the evidence. Once we've heard all of the evidence, then I'm going to give you written jury instruction about what to do in the case, how to apply the law to the case, and then how to reach a verdict. So you don't have to go out and educate yourself on anything. You don't need to go. Matter of fact, I'm going to instruct you not to. Don't go get on Google. Don't Google any of the terms that you've heard today. Don't try to find out more about the defendant or the attorneys for the state or the attorney for the defendant. It's best that you do nothing other than show up, be attentive, listen to the evidence, listen to the law, and then follow the law when you apply the evidence to reach your verdict. That's all you need to do. Okay. We will give you a phone number so that you can give your loved ones, so that when you're in here, I'm not going to allow you to have your phones present with you in the courtroom. And as a matter of fact, when you go to deliberate, I'm not going to allow you to have your phone at all. At jury deliberations, we'll take your phone so that we know that there's strict confidentiality back there in the jury room. No one else will be present with you in the jury room, not a bailiff, not an attorney, no one. And so we'll keep the phones out here. So if there's an emergency, we'll have a phone number for your loved one or whoever needs to reach you to call. And then we can interrupt whatever's going on, whether we're in trial or jury deliberations, to get that message to. Okay, so that's why we ask for two numbers. Okay, so we can reach you at home, and then we'll give you that phone number so that they can reach you while you're working. Okay, we've already had a complaint about it being a little cool in here. I'm going to keep it cooler than I am warmer. So bring a jacket, bring a sweater. If you need to bring a little blanket or something, that's fine. I'll do that. I do not allow food and drinks in here because it always tends to make a mess. So you are welcome to bring water. You can bring food and drink with you, and you can keep it in the jury room. I have no problem with it being in there. There's little cubbies in there where you can put your personal belongings, bring your food and your drink in there. Do I have any diabetics or anyone that has to regulate blood sugar? Do you? Okay. Do you have a monitor that you need to bring with you? No? Okay. If you do, that's fine. Just want to make an accommodation for that, but you're welcome to bring food, drink, keep it back there. When we start, we'll probably go about an hour and a half before we have a break. All right. If something comes up and you need a break, just raise your hand, let me know, and we'll break when we need to. Okay. Otherwise, we'll go about an hour and a half and we'll take a 15, 20-minute break and then we'll resume. So if we start tomorrow around 2, then around 3:30, start at 1, around 2:30, and we'll break. And then we'll try to finish every day as close to 5 as possible. On Wednesday, you're going to arrive at the courthouse no later than 8:45, be in the jury room, and we'll just get started at 9 a.m. We'll go 9 to about 10:30, take a break, and we'll work up till noon, take a lunch break, and we'll come back about 1:15, 1:30, depends on where we're at. I'll try to stop us as close to 5 as possible. Do I have any daycare issues in here with any kiddos that need to be picked up at a certain time? No? Okay. We'll still try to stop as close to 5 as we can, unless there's a witness or someone who's taking a little bit longer. We may want to finish that up before we continue. The attorneys are still confident that due to the number of witnesses and evidence in this case, that we're likely to be done by Wednesday, even starting tomorrow afternoon. So things may move quickly. And if they do, then I'm going to have some notebooks available for you tomorrow so you can take notes. You're welcome to do that. You're welcome not to either, just whatever, is your preference. So you can take notes and that way you can refresh your recollection about what the testimony is. Then after you've received all of the evidence, you've received the court's instructions, then I'm going to give the attorneys for the state, the attorney for the defendant, the opportunity to give their final arguments. After that, then it's your job, it's your turn. I'll send you to the jury room, you'll deliberate, and we'll reach a verdict. All right, so let's see, parking. Probably the best place to park is either at the city of Canton, parking over here underneath the water tower area, or over the Van Zandt County Courthouse Annex, that's public parking. We ask that you not park around the square because we do have commercial vendors, businesses here that are relying on those parking places. So don't park in any private parking lots, okay? So it's best to be at the courthouse annex on the other side of the mobile gas station on the south side of the cemetery, the first Monday over there. Also, when you come in, we're going to have plastic magnetic jury badges for you to put on, so that I ask that you wear those on the outermost part of your clothing, so that when you're walking around the courthouse, people will know who you are, what you're doing, number one. And number two, it allows the attorneys the benefit of knowing if they're working on their case outside in the hallway, they'll know not to say something within your presence that you don't need to hear. Everything that you hear in this case should be here in this courtroom, either under the rules of evidence or the rules of procedure. Okay. Alternate juror, sir, you are a part of the jury, but when it comes to deliberation, not even the law doesn't even allow you to be in there. So when the jury goes to deliberate, as long as none of these 12 are unable to fulfill their duty, then at the time they deliberate, you will be separated from them. Should one of them not be able to fulfill their duty and they're discharged from the jury, then and only then will I install you onto the panel for you to deliberate. But in the meantime, you will do everything else they do. So when they exit, you exit. When they enter, you'll be back there for all of the jury stuff except for deliberations, unless you're placed on the panel. Okay, and it's my policy to always have an alternate, even on short trials, because I've learned that lesson the hard way. And when I don't, if we have an emergency or someone gets ill and our jury becomes less than 12, then it creates other legal obstacles that the court has to overcome. So I just err on the side of being more cautious. Okay. Do y'all have any questions at this time? Yes, ma'am.
Should we plan on trying to take Thursday off just in case, or is it pretty set in stone that we'll be done by Wednesday?
Nothing is set in stone, but I don't think you need to make arrangements for Thursday. In the event, the attorneys are very confident that we will hear all of the evidence by Wednesday. So if there's deliberation, we may deliberate into the evening if it takes, several hours. Let's say that you don't get to start deliberating until 2 or 3 in the afternoon on Wednesday. You deliberate 4 or 5 hours, and what we'll do is we'll just stay here until your deliberations are over, which means it could be into Wednesday evening. I will do my best to avoid Thursday. Question? You've got this curious look on your face, like.
I just for work. I apologize. You're safe.
Okay, well, I guess you can always surprise them if you show up, and they won't be surprised if you're not there. But if you take off Thursday and we don't go Thursday, I won't answer my phone until next week. So you're on the honor system when you're in grade. So those are good questions. Any other questions? Okay, then let me give you some instructions here. During the case, no communication is going to be permitted. So you're going to be instructed that you're not to discuss this case with each other or anyone else. Okay, so that means first witness gets on the stand and they give their testimony and I call for a break. It'd be improper for you to go back and go, hey, what y'all think about that testimony? Think that person lying? Truth? What do you think about that evidence? You're not going to be permitted to discuss any of this until you receive all of the evidence, court's instructions, and the closing arguments. Then I will tell you, now's your time to deliberate. Then and only then will be your opportunity to discuss what you've heard in this case with each other. You're not to discuss it with anyone else. So you're not to go home and give a Facebook update or a YouTube update about what happened in court today. You're not to discuss this case with anyone else at all. Doing so would be a violation of your oath, and it would be jury misconduct. You could be held in contempt. So it's very important. If anyone attempts to communicate with you about the case, your other jurors, anyone outside the jury, then I want you to report that to Deputy Martinez. He'll be the bailiff who has you in charge. You report that to him, and then the court will deal with that. As I mentioned before, do not read newspapers, do not watch television, listen to, you can tell how old these things are, listen to radio reports. We need to ask some things. Don't go on social media or things like that, trying to learn more information about it, okay? No outside investigation is permitted. It is important that you pay attention, as testimony will not be repeated for the purpose of repeating it. Sometimes juries think that they can get back into the jury room and send out a note and say, hey, we would like to have all of that testimony read to us again. Well, you'll find out at the end of the case that it's not. The law doesn't allow that. The law allows for the jury to request that certain portions be read back only if it is in dispute, meaning that some of you have different recollections of what it is, and you need that to be clarified. But for purposes of just refreshing our recollection about what everyone said, it's not permitted. So it's very important that you pay attention. If you can't hear a person testifying, raise your hand, let me know. I'll be paying attention to that, as will my staff. So I will make them speak into the microphone. If I need to turn the air off, I'll do everything to make it, to encourage them to make it to where you can hear and see everything. If we watch a video or photographs that you can't see, raise your hand and let us know. We won't know otherwise. Okay. You're reminded that the statements that you're going to hear by the attorneys, including their opening statements, closing arguments, their questions, are not evidence. The evidence will come from the witness stand and through exhibits. I've already discussed objections. Those are normal legal procedures by the attorneys. So when an objection is made, the court must rule on it. Don't conjecture, don't speculate, don't worry about what that is. I'll deal with the legal aspects. You'll deal with the factual aspects. You're the judge of the facts, credibility. I'll judge the legal issues, okay? I think that is it for the most part. Any other questions before we go? All right, so everyone try to be here by, say, 12:45 tomorrow. Deputy Martinez will give you more information about that. And then if you have any issues, he'll have a number for you to call. Just any issues arise in the morning, and give us as much notice as you can. Give us a call, okay? All right, so one last thing. When you exit the courtroom and when you enter the courtroom, because you are the jury, we are all going to stand in your honor, okay? So that means you come in, you don't have to remain standing because you are the jury. We're standing for you. So you just come in and be seated. And the only assigned seats in here are the alternate. He's the only one that's got that seat over there. So if any of you need to move around, you don't have to wait for someone to get to a certain seat unless they told you they want that seat. Okay, so if those of you who are in the back row need to be in the front row, if it helps you, then make an accommodation for that. Let people know, be the first one out the door. But these are not assigned seats. Okay, all right, all rise for the jury. Jury will step into the jury room. Deputy Martinez.